As I mentioned before, while I think it's there, as you read the whole thing, I think it maybe should specifically be said that each one of these criteria must be met in order to grant a use variance.
Okay.
So you're saying, Marcia, that each one of these numbers you want to state that in a sense?
No, but I think, in other words, at some point, just saying all of these, you just can't say, well, you have to,
Right.
you have to,
And that's what the law says anyway.
It's basically, yeah, it's not 7 out of 10.
Right, it's gotta be
It's gotta
10
be
out of
all.
10, yeah, for the use, not for the area.
Yeah. The Board of Appeals shall, in the granting of use variances, delete the second shall, have the authority to impose such reasonable conditions and restrictions as are directly related to and incidental to the proposed project. Such conditions shall be consistent with the spirit and intent of this law and shall be imposed for the purpose of minimizing any adverse impact such use variance may have on the neighborhood or community. Such conditions may include, but are not limited to, landscaping, lighting, access and egress, signs, screening, architectural features, location and layout of buildings, limitations upon the use or characteristics of the use which are reasonably related to the public health, safety, and general welfare, and as may be necessary to carry out the intent of this law, which should be capitalized. If the applicant refuses to accept such requirements and conditions, the use variance shall be denied. I should say the use variance application. 6. In addition to all other application requirements from time to time established pursuant to law and this law, the following reports shall be required to be submitted in connection with any appeal or application for a use variance concerning what is otherwise an explicitly prohibited use as defined in new Article 6A. The purpose of these reports in the context of otherwise explicitly prohibited uses is to assist the Board of Appeals in its determination as to the impact of a proposed project on the town and or the essential character of the neighborhood, and to determine whether the proposed project complies with the requirements of this law. A. Environmental assessment form, lawn form. B. Description of surrounding uses. The approximate location of all neighboring residential, hamlet, do we have hamlets here?
Their village.
Villages. Park, recreational, and/or agricultural areas, all county-designated unique natural areas, and locally designated critical environmental areas, if any. All wetlands, intermittent, seasonal, and other streams, rivers, and waterways, significant natural communities, endangered and threatened species and species of concern, and historical or archaeologically sensitive or mapped areas within a 2-mile radius of the perimeter of the site of the proposed use. C. Traffic impact report. The traffic impact report containing 1. The proposed traffic, let's say a proposed traffic circulation plan. The projected number of motor vehicle trips to enter or leave the site, estimated daily and peak hour traffic levels. 2. Existing and proposed daily and peak traffic hour levels as road capacity levels. 3. A determination of the area of impact of traffic to and from the proposed project. 4. The proposed traffic routes to the nearest intersection with an arterial highway, including gross weights and heights of vehicles. 5. The proposed traffic flow pattern, including vehicular movements at all major intersections likely to be affected by the proposed project. 6. The impact of this traffic upon existing abutting public and private ways in relation to existing road capacities. 7. The traffic impact analysis of the effects of the proposed project on the transportation network in the town using passenger car equivalents. You can't simply say, you know, one tractor trailer is not the equivalent for road wear as one passenger car. So that's what that's saying. 8. Articulation of the effects and impacts of the proposed project on traffic based on existing conditions and projected future background traffic on the state, county, and town road system. 9. Evaluation of whether the resulting traffic conditions are likely to hinder the passage of police, fire, and emergency response vehicles or degrade the quality of life and or otherwise contribute to hazardous traffic conditions. And 10, determination of whether there is sufficient road frontage so that any vehicle leaving the site may turn into the lane of traffic moving in the desired direction and be channeled within such lane before crossing the nearest intersection or proceeding along the road, and any vehicle entering the property may turn out of the nearest lane of traffic without interfering with other traffic. D, as in David, road impact report. An evaluation of 1, appropriate roadway geometry, including required road widths, bridge widths, starting and stopping site distances, intersection site distances, horizontal and vertical curves along the proposed traffic routes. That's something that people forget all the time. There's a lot more going on with this kind of use than the weight capacity of a road, because these are long vehicles, and many of them, can't turn a standard corner without widening and things like that. 2, the adequacy of existing pavement structures along the proposed traffic routes to accommodate the full weight of any high-impact trucks likely to be used in connection with the proposed project. And any impact to the rural or scenic character of any roads along the proposed traffic route. E, transportation plan. A description of ingress and egress through the proposed project site through which equipment and supplies will be delivered and which will provide access during and after construction, and identification of any roads, streets, intersections, bridges, and other facilities along the proposed traffic route that do not meet New York State Department of Transportation standards. Such plans shall describe any anticipated improvements to existing roads, bridges, or other infrastructure, any new road or access construction, measures which will be taken to avoid damaging access traffic routes, and measures that will be taken, and measures that will be taken to restore damaged routes following construction, and measures to maintain the scenic and or rural characteristics of such roads. F as in Frank. Noise impact report. A report on the following topics. 1, the existing audible conditions at the project site. To identify a baseline sound presence and pre-existing ambient noise, including seasonal variation. 2, a description and map of sound-producing features of the proposed project from any noise-generating equipment and noise-generating operations that will be conducted in connection with the proposed site, including noise impacts from truck traffic traveling within the town to and from the proposed project. 3, for the noise generated by construction and use of the proposed project, the range of noise levels and the tonal and frequency characteristics expected, and the basis for the expectation. 4, a description and map of the existing land uses and structures, including any sensitive sound receptors, i.e., that is, residences, hospitals, libraries, schools, and places of worship, parks, and areas with outdoor workers. Within 1 mile of the project parcel boundaries. Said description shall include the location of the structure/land use, distances from the proposed project, and expected decibel readings for each receptor. The report shall cover low frequency, A-weighted, infrasound, pure tone, and repetitive impulse noise. And 6, the report shall describe the project's proposed noise control features, including specific measures proposed to protect off-site workers and mitigate noise impacts for sensitive receptors. G, visual assessment. A visual presentation of how the site of the proposed project will relate to and be compatible with the adjacent and neighboring areas within a 2-mile radius of the perimeter of the site of the proposed project. This presentation shall include computerized photographic simulation showing the site during construction and fully developed, and demonstrating any visual impacts from strategic vantage points. Color photographs of the proposed site from at least 2 locations accurately depicting the existing conditions shall be included. Your site plan group may do this now, and probably does already but the study shall also indicate the color treatment of facilities components and any visual screening incorporated into the project that is intended to lessen visual prominence. H, Report of natural gas and/or petroleum extraction, exploration, or production waste and other waste. A report containing the description of natural gas and/or petroleum extraction, exploration, or production waste as defined in section 684, and other solid waste, industrial waste, hazardous waste, and pollutants expected to be produced, stored, injected, discarded, discharged, disposed, released, or maintained on the project site if the variance is granted. I. Compatible uses report. A discussion of characteristics of the proposed project that may decrease the town's and/or the neighborhood's suitability for other uses, such as residential, commercial, historical, cultural, tourism, recreational, environmental, or scenic uses. J. Fiscal impact assessment. An assessment describing the adverse effects and impacts on town revenue and costs necessitated by additional public facility and service costs likely to be generated by the proposed project. K. Fire prevention, equipment failure, and emergency response report. A report containing 1. Description of the potential fire, equipment failures, and emergency scenarios associated with the proposed project that may require a response from fire, emergency medical services, police, or other emergency responders. 2. An analysis of the worst-case disaster associated with the proposed project and the impact of such a disaster upon the health, safety, and welfare of the inhabitants of the town and their property. 3. Designation of the specific agencies that would, should say respond, not response, respond to potential fires, equipment failures, accidents, or other emergencies. 4. Description of all emergency response training and equipment needed to respond, not response, to a fire, accident, equipment failure, or other emergency, including an assessment of the training and equipment available to local agencies. And 5, the approximate or exact location of all fire, police, and emergency response service facilities within a 5-mile radius of the perimeter of the site of the proposed use.
David, on that third sentence down, scenarios associated with the proposed project, you do want to put the with in there? So scenarios associated with the proposed project that you said.
Got it. Thank you.
All right.
L. Public facilities and services assessment. An assessment describing 1. Whether current town public facilities and services, including water supply, fire protection, school services, recreation facilities, police protection, roads, and stormwater facilities, are adequate for the proposed project, taking into account all other uses that have been permitted or are currently operating in the town. 2. A comparison of the capacity of the public services and facilities to the maximum projected demand that may result from the proposed project. In determining the effect and impact of the proposed project on fire, police, and emergency services, the review shall take into consideration response times and the number and location of available apparatus and fire, police, and emergency service stations that are manned by full-time professional service personnel. And where applicable, calculation of response time shall also include the time it takes volunteer emergency personnel to get to their stations. And 3, a review of the impact of the proposed project on the safety of all children going to and from school by car, bus, bicycle, and walking during and outside of school zone hours, and whether safety measures such as signaled crosswalks, elevated sidewalks, green space buffers for pedestrians or bikes where established, walking bike route overlap run, change that, run along intended truck routes so as to prevent accidents. M, property value assessment. M is in Mary. A property value analysis prepared by a licensed appraiser in accordance with industry standards regarding the potential impact of the project on the value of properties adjoining the project site. N is in Nancy. Health impact assessment. A human health impact assessment that identifies ways in which the proposed project would adversely affect the health of town residents and a priority list of recommendations to minimize the potential health impacts of the proposed project. The health impact assessment shall include 1. A risk assessment of possible impact of chemical exposure on the health of residents, including the chemical abstract service number of all chemicals proposed to be used or generated at the project site. 2. An assessment of possible health effects due to industrial operations in non-heavy industrial zoned areas. And 3, an assessment of possible health effects due to community changes, including, I think I'm missing an article there. No, you got it. You got it. Including the presence of an industrial activity in a previously non-heavy industrial area, declining property values, impacts to the education system, and sudden changes in population numbers, demographics, and customs. B, area variances. In making a determination whether to grant conditionally or deny an application for an area variance, the Board of Appeals shall take into consideration the benefit to the applicant if the area variance is granted, and balance this benefit against the detriment to the health, safety, and welfare of the neighborhood or community by making such a grant. In making such determination, the Board shall consider each of the following factors. A, whether an undesirable change will be produced in the character of the neighborhood or a detriment to nearby properties will be created by the granting of the area variance. B, whether the benefit sought by the applicant can be achieved by some method feasible for the applicant to pursue other than an area variance. C, whether the requested area variance is substantial. D, whether the proposed area variance will have an adverse effect or impact on the physical or environmental conditions in the neighborhood or district. And E, whether the alleged difficulty is self-created. Which consideration shall be relevant to the decision of the board, the ZBA, but which consideration shall not necessarily preclude the granting. What that, I'm going to clean that up.
Yeah, because that appears that the whole thing
right.
could be that, it's
Right.
only the self-created.
It only results to E. And those factors are all supplied by statute. The Board of Appeals, in the granting of area variances, shall grant the minimum statute and case law. The Board of Appeals, in the granting of area variances, shall grant the minimum area variance that it shall deem necessary and adequate, and at the same time preserve and protect the character of the neighborhood and the health, safety, and welfare of the community. 3, in addition to the application requirements from time to time established pursuant to law and this law, applications for an area variance shall contain a typewritten narrative explaining what the application is for and how the permit meets or exceeds all of the criteria for an area variance. 4, the Board of Appeals shall, in the granting of area variances, have the authority to impose such reasonable conditions and restrictions as are directly related to and incidental to the proposed use of the property. Such conditions shall be consistent with the spirit and intent of this law and shall be imposed for the purpose of minimizing any adverse impact such area variance may have on the neighborhood or community. If the applicant refuses to accept such requirements and conditions, the area variance shall be denied. Bottom of page 20, section 2.13 of the draft, referring to Article 21 of the existing code.
Wait a second, before we go forward.
Sorry.
Marcia, you're, without Bruce being here, you're pretty much the expert when it comes to ZBA stuff, and particularly with area and use variances. And so, and you of all people have expressed major concerns about.
Yeah, I would find this would be a great service and map for the board when these matters are brought before them. It's too ambiguous. If you look back, for instance, in our zoning, it says nothing. It really doesn't give set forth the criteria at all. So I would certainly encourage the board, when it gets to the board, to adopt those particular areas, the variances.
Okay.
And just to note for everyone, that long list is only specific to the 6A, right?
Correct.
Okay.
Right.
So that's new to all of us.
Everybody's comfortable with that, and with Marcia's opinion on that? Okay. Thanks, Dave.
Sorry, I didn't mean to.
That's okay.
Bottom of page 20 of the draft, section 2.13 of the draft references section 21, which is on page 33 of the existing ordinance. And that is severability, what they call separability, and we are putting the following in. If any word, phrase, sentence, part, section, subsection, or other provision of this law, or the application thereof to any person or to any circumstance, is adjudged or declared invalid or unenforceable by a court or other tribunal of competent jurisdiction, then and in such event, such judgment or declaration shall be confined in its interpretation and operation only to the provision of this law that is directly involved in the controversy in which such judgment or declaration is rendered, and such judgment or declaration of invalidity or unenforceability shall not affect or impair the validity or enforceability of the remainder of this law or the application hereof to any other persons or circumstances. If necessary, as to such person or circumstances, such invalid or unenforceable provision shall be and be deemed severed herefrom, and the town board hereby declares that it would have enacted this law or the remainder thereof, even if, as to particular provisions and persons or circumstances, a portion hereof is severed or declared invalid or unenforceable. What this does, the legal effect of this, and you had this clause in before, but this one is a little heftier, simply says that you don't throw the baby out with the bathwater. If there's a particular provision in here that a court thinks should be pared back, they'll simply pare it back, as opposed to invalidating the entire law.
So we're basically removing section 21 under separability, the sentence that says the invalidity, thank you, of any section or provisions of this ordinance shall not invalidate any other section or provision thereof. So replacing it with that weightier.
Yep.
Okay.
Yep.
Everybody's okay with that?
Yes.
Okay. Now, now on page 21 of the draft amendment, Article 3, severability and effective date. 3.1 is severability again. The one we just put in, we put into the zoning code. The one I'm about to read, which is basically, I would assume, identical, is identical, but this is in our zoning amendment. We want the same severability protection that we have in our amendment that we have in the code itself. Okay? And it just seems weird and feels weird because it just happens to come after the one there.
So
So you're going to place it at the end of 6A, you're saying? You're going to put one there and then one at the end? Is that what-
No, but in this piece of paper,
Yeah.
the zoning amendment, which does a
Okay,
number of
amendment.
things. Yeah. So we don't need it at the end of 6A because we now have it, this new language in present 21.
And that's exactly the same language of what you just read.
Right.
Yeah.
Okay.
The only difference is that when I read it the first time, we were putting it into the zoning code.
Correct.
We have it here because it's in our zoning amendment. We want it in each piece of paper. Okay? Shall I read it out loud again?
Yeah, we just read through
Thank you. Thank you.
exact same thing
Thank
you
you.
just read.
And I will, on my own, so that nobody is in any way misread or led, I'll double check to make sure that it is exact. It should be.
We will too.
Okay. Lastly, 3.2 is the effective date of this local law. And this is nice and short. This local law shall be effective upon filing with the Office of the Secretary of State, and the town clerk is directed to immediately file a copy of this law with the Secretary of State as required by law. That's it.
Okay. Thank you, David. I know that was not,
No, it's fine.
only 3 hours.
Yeah.
That wasn't bad.
Now, I guess the next question is, do we want to look at this or when are we going to meet again?
Well, I think that basically David needs to get us the,
No, I thought you were,
the appendix.
yes.
Okay. Well, I don't want to do it right now. Do you want to do it right now? Do you
Well,
want
we
to
can
hammer
do
it?
it
It's what, 4
certainly,
pages?
we've got 2 weeks to get this done.
Next, I'd have to look at my calendar.
Why?
Next week is a board meeting, but that's the that's not the informational session.
I think it is after that.
This is a regular board meeting.
Yes,
Yes,
that's what I'm saying, but then,
February 29th, I have as the information session.
The 29th is the information
Oh, right,
session.
okay.
And then the public hearing is the following 2 weeks later, right, on the 14th.
The 14th,
Let me just grab my other calendar. Just to make sure that I know exactly. All right, so, on the 15th, although it's a town board meeting, we are to approve the form of the law and the secret form of resolve to send it to the county. So that's to be done on the 15th, and then on the 29th is the informational session, and then on the 14th is the public hearing, is the county has to have it for 30 days. They would get that back to us on the 19th. And then we would have on the 28th, actually, I'm sorry, they'd get that back to us on the 18th, which is a Sunday. And then the 28th would be the special meeting to pass a law.
29th?
It's actually the 28th, because all these move to Wednesdays.
That's 29th.
I've got March 28th.
So I'm
I'm sorry, March 28th,
So
yeah.
what's February 29th?
February 29th is the informational session.
So what you're saying, Chris, is next week?
Wait a minute, sorry.
So-
I thought what we did last week was an information session. So
No, that was for the board. The informational session is on the 29th,
I've got that, right?
and then the public hearing is on the 14th. So according to what I have is that next week we're to approve, the board is to approve the form of the law and the seeker form, the long form, and to resolve to send it to the county. Now, that doesn't mean that we can't change it based upon information from the session and the public hearing.
And it doesn't mean, by any stretch of the imagination, that the board has decided to pass
Right.
it in any format or otherwise.
But the county has to get it for 30 days prior to us having the special meeting to pass the law. The county has to review it.
But the board has to do the secret. Now,
Correct. Well, the
right, so
secret
that
form-
has to be done at the board meeting.
Correct. The long form. Right, which Helen has done most of that for us. Right. So then we need to go through the appendix, or we need to do it now, but ultimately I would think that we would set up another day to do this because
I just want to clarify, what Helen's done is set it up for you guys to evaluate it and
Right.
decide. It's not that, anything's been completed ahead of time.
Right, right. No, we totally understand. I apologize if I misconstrued in that statement. So do we want to, I would assume we would want David to go back and make the changes that we've talked about tonight.
Yes.
And then meet before that next Wednesday to go through those changes and this appendix. We could do that with David either via Skype or on the phone. We don't have to come for that. But we should have that meeting prior to next Wednesday. We can have
And
it.
enough time for any changes to be, that we feel should be made. To
Absolutely.
get.
So, we could do that next, I'd have to look at the calendar for what's in here, but probably next Monday.
Unless it's a planning board.
Unless it's, yeah, I'd have to look at the calendar, check with Ken, but why don't we tentatively plan it for next Monday night? Is
6:30.
that okay? Does that work with everybody?
That's February 13th, right?
Yes, February 13th. Why don't we plan it?
I can't, my school's like,
Okay.
So then
So what
let's,
can you do?
well, basically, I think virtually every night during the week, including some weekends, we're someplace.
right.
Now, if there was, for example, on the 13th, actually the employment for the town working. But is it something we could do earlier in the day?
Sure.
I
I'm available during the day. Margaret's available during the day. Tricia?
Monday during the day?
Yeah, or Tuesday.
We're just,
Monday
we're
during the day, fine.
That's
essentially
fine.
talking about the appendix. I don't anticipate, these are all pretty straightforward changes, so I don't
Right.
think you're gonna be okay with them.
So Monday during the day works for you, David?
Yeah.
Okay, at what time works for you?
I had set, like I said, I had set, how far away from, I had 7 o'clock in front of us.
Anybody have nine?
Monday is about 45 miles away.
How many?
45.
Okay. You have that at what time?
7.
AM?
No.
Oh, PM, sorry. I've been here 3.5 hours.
Unless we're also.
I was up on my farm at 4 o'clock this morning, so I'm really not up this late. Okay, so then let's, you want to say 4 o'clock? 3 o'clock? I mean, I'm
It's
just
gonna
getting
be
tough.
tough, if it's 45 minutes, miles is not,
You want
I would
to
say
say
just to be
2?
safe,
3
yeah.
o'clock? Okay.
I was gonna even say 2, I mean, it may take a while to go through
You
this.
want to do 2 o'clock?
Yeah, I'd rather do 2 and have too much time and then,
All right, so Monday,
That's 13,
February 13th,
2 o'clock. Here,
2 o'clock here, yeah. Yeah, that shouldn't be a problem, there's not, yeah, Mondays are pretty slow here. Yeah. Okay. Okay, and you'll be able to email us something possibly by the end of the weekend with any changes? Or
and
that-
week, yeah.
All right.
What's today's one, Wednesday or Thursday?
Wednesday.
Oh, yeah, I can get you something.
Okay.
So on Friday.
Okay, that'll allow us to, and then we'll just forward it on to everybody, and that'll allow us to review it over the weekend and then come back and talk about it on Monday. Okay, anybody else in the committee, any comments, any questions related to this? Okay. Folks in the audience, this is a, okay, yep, thank you, absolutely, David, good job.
Thanks.
Folks in the audience, the way this works, this is a committee that's, we're allowing the public to observe and to come. Anybody who wants to make a comment are welcome to. You need to state your name and where you live. If you are a Milford resident, you will speak first. If you own land in Milford, you will speak second. And if you are not one of those, you will speak last. So any...
and it should address the subject matter only.
Right, it should address the subject matter that we've talked about. So any comments or questions from the audience? Yes, and please state your name.
My name is David Whiteman. I'm a resident of this town. I'm a business owner in this town. How many people here have ever read 1984 by George Orwell?
Okay, I better object.
No. That's
This
to make a
is time-
specific point.
Excuse me, sir, this is time to comment on one of the articles.
And that's exactly what I'm
That is
doing.
to wait for the public
Oh,
hearing.
thank you very much. I am really impressed by what a good job you've done here as an audience, okay? Because when the people of this committee were confronting the town board of the town of Milford in the past, there has been no such,
Restriction?
no, there's been no such polite form taken. Right.
You're talking to us,
It is a conversation coming
and
up.
this is an advisory board.
This is
I
not the
agree.
town.
It's not the town board.
So if
And
it-
we're
that's
asking
it,
the-
Marcia,
And I'm just saying, these people have done a great job here.
Okay, but how is that relevant to the
would
specifics
you
of
like
what
to
we're
comment?
doing?
My specific report, my specific point is, all right, and the point of reading George Orwell is that I cannot believe that anyone in their right mind would consider putting that much restriction on every individual and business in this town going forward and still consider this a decent place to
Can you
live.
be specific, sir?
The
That's-
last section that we addressed.
That
that
only
was
has to
6
do
pages.
with hydrofracking.
It does?
Yes,
Yes.
sir. That's, I specifically
It
asked.
only has to do
That's
with
correct. That's correct. Do
I,
you have your draft with you?
it's right here.
Please
I
read.
think he's about to,
Please read.
maybe he was
Yeah.
about to say I stand corrected. Is that what you're about to say?
Variance. Variance.
The variance, the part that was the long one is just about 6A, sir. About the hydrofracking. If someone were to come in,
Well,
showing
you know what?
road.
So comment noted,
Right.
and
Yeah.
we're gonna, we will respond in our drafting, the committee will, and then at the town board level, by simply saying that that was a misimpression, and this clearly says explicitly
6A.
that the language he objected to was only in the context of a 6A variance.
Please read 1984.
Any other comments from Milford residents? And please state your name and where you're from, and your address.
I'm Arlene Benedict, and I have been lived in the town of Milford for 45 years. Do you need my address?
No,
No.
but we already have people do that at the other meetings, but go ahead.
Oh, okay. Well, first of all, I was going to thank the town board members, but they're not here. So I'm glad that they passed pro bono, the Slottje, is that how you say it, lawyers.
Close enough, yep.
to advise on drafting a local law to amend and supplement our zoning law. And I want to thank the town residents who agreed to be part of the committee.
Arlene, in all fairness, you're not addressing what we discussed tonight.
There's going to be
Fairness is
plenty of
fairness.
opportunities at the hearing and the informational session for the public to express their comments.
One way or the other.
We as a committee are only looking at comments, as we expressed to David, Mr. Whiteman, related to this specifically.
Yeah, well, there's one thing in relation to flashing lights. What about high-intensity lights? And I'm not sure where it is right now.
We'll, so the question is to see whether we want to augment any of those things, those standards or requirements in special permit context perhaps, or in variance context. In any event, we'll look at lighting as well and see whether we'll look at that.
Okay. Any other residents? Yes, yes. And state your name.
Penny White, Cushman Junction, own property in town. As the document, well, I have one comment. I sit on a state board. I've been to open meetings, sessions and training sessions, and I'm concerned about the use of sniping or.
It's actually at the newly elected officials training school. They said it's absolutely acceptable. You cannot call into a meeting, but if you can video conference, if you are, and this is a committee, so it doesn't fall under those laws, but if you are a town board, the only thing that Vince would have to do, if he was a town board member, which he is not, he would have to make an invitation to the community where he is at in Florida for people to come into his house. And this is a new thing that Barbara, Marcia, and I, and all the newly elected officials training school that attended, all the newly elected officials who attended training school put on by the Association of Towns and the Comptroller Office advised us on. So according to the state, they encourage video.
That law, because
Well, we would just encourage you to contact
This
Comptroller.
is one of the
It's
lectures.
very obvious and very straightforward that video conferencing is now allowed in the state.
you get a trip to New York City.
Absolutely.
As the committee looks at this, I'm hopeful that they'll look at it with an eye of the unintended consequences that seem so appealing to support the issue that we're addressing today, but could conceivably, in my eyes, be used against industries that could want to locate here in the future or who actually exist here now. So I'm very fearful about that because all of the issues, noise impact, highway impacts, I really think you need to seriously consider. We just want to ban this now. I see this as a potential for banning other activities in the future, which setting precedent. I also, when you talked about the demonstrated requirements for variance, we talked specifically at one point about the adverse cost to the town. I think you would have a stronger position if you spoke in terms of cost benefit, because then indeed you would open the door for whoever's coming in to defend their position plus and minus, so that again, I think you went back to facts and circumstances that said you didn't want to have preferential treatment. And I think it's appropriate to give that opportunity to say, is there a potential for pluses in this request for variance? And that was at the end section. So it just spoke to adverse cost to the town. I think better yourself, I think it would be better perspective to be had if you look at a broader picture.
We'll take that into account as on the committee. The law doesn't do that. In the context of the use variance, it does do that. It does have essentially what's a balancing test in the context of an area variance, but they're very specific and explicit differences between use variances. And so we don't want the law supplies that standard. We do not. It's up to the committee, but
I think it's
but
a
that's,
point that may be well taken.
it's not what the law says, but we'll certainly evaluate.
I was confused about the status of electric co-ops when you were speaking about utilities, and I'm not well versed in this, but I do know we have regional co-ops. There is an Otsego County electric co-op, and so consequently, I don't know if they fall under the auspices of a public utility, and I don't think, again, I'm not well versed enough in this, but I don't.
Do you know where that would, what you're, what
That was
you're
at
saying?
an early.
I know where it is. That's a great point. What's the name of it?
They're electric
They're-
co-op,
Yeah.
and they're in parts of the town of Milford.
And, let me see.
Thank you, that's a great point.
And I think,
Well, I'll find the answer.
yeah, I think that that's all the specific things I can come to. Again, I'm a little concerned about shooting ourselves in the face as we speak to rural nature of the community. Are we digging ourselves a hole by just focusing on this one issue that might come back to haunt us down the road? And I know we can't see into the future, but I think it's worth, as you read the document, to take that context into mind.
There's a balancing, as the draftsperson of this, albeit he has to decline, there is a balancing. Unintended consequences, always, no one can see in the future, but you're right, we always want to look into it. But we're trying to balance on the other side is the unintended consequence, or presumably unintended, although not always unknown, consequences of allowing this particular industry in. This industry, everywhere it's gone, everywhere, without exception, has had what can charitably be called unintended kinds of consequences. So we're trying to benefit, or balance rather, the difference, on one hand, those unintended consequences that virtually invariably result when this industry comes to town, with the kind of unintended kind of consequences that you quite properly are concerned about. So we'll take that into account.
And last, and I'm not saying this to be offensive, but I'm a little concerned about the tone relative to the document that exists. And I continually get a feeling that this was done by buffoons. And I would again, I voiced this at the last meeting, I would hope that you would look at this as a document that is constantly evolving. And be really careful about who you term as we and I, and this is the town's document. And I think the people who drafted it before were doing what they thought was the best thing at the time. And so this notion that we need significant structure, there's an advantage to structure. I've served on enforcement committees, and when there are very defined lines, it gives you that bright line. But I'm an accountant, and I know for every bright line, there's somebody out there trying to jump over it. And so perhaps when you look at the document, perspective on how much definition do we need against how much flexibility we can give to those people who we've been trusted to use good judgment in their position, as we have with you, in the full context of the document. Just keep that in mind when you review. I think there's validity.
We'll take your comments under advisement. Okay?
Thank you.
Yep. Any other residents of the town of Milford? Are you residents of the town of Milford?
Yes.
Okay, please.
Kimberly Moore, and I lived on Bridger Lake for 43 years. I'm extremely concerned with this document, and I've been to
Specifically
literally
related to
hundreds
the
of meetings. Yes, I believe I've sat here for 4 hours. I couldn't have a say in this. The taxes and everything else, the variances that you have in here, you talked about farming and not being able to farm, or taking the farming variance out of this. There's a Right to Farm Act in New York State.
Nobody took a
Sir,
farm.
no,
In your document.
No, you're wrong. You
No.
misunderstood.
The letters say.
She has the floor.
You take it
In
as.
your
This
document.
is a committee, and we have the right to also state during a comment whether or not a statement is false or true. And that statement is false.
Okay, well,
And she has the floor.
I would like to say several comments that you made, or things that you put in here that are false. The mining reclamation law for the DEC versus oil and gas, who has the right to decide who's regulating that or banning that in New York State. New York State has said that the DEC is the only one that has the right to do that. I have a question. Has the CEDC recommended that the town of Milford ban and put in an enact a ban in the town of Milford?
The CEDC?
Us?
What is the CEDC?
We've not, us.
Oh.
No, I'll answer that question. We're not,
So,
may I answer the question?
yes, absolutely.
Completely without, we have not made any recommendation along those lines. What we listened to is what the client told us tentatively should go into this. And that's what this is.
Okay, so the town of Milford then is your client? Is this
Absolutely,
Slottje4?
absolutely.
And we made a
And
recommendation.
so when I place a lawsuit against the town of Milford, you will be representing them as the litigator?
No, not necessarily, not at all.
But-
No, I need to
let
know
me-
this. I'm
let-
asking
The
him.
question,
That's the choice.
let me say two things with your camera on.
I don't have a camera.
Okay, I'm sorry, I thought it was yours.
That's me.
Okay, let me tell you two things. The town of Milford is our client, unequivocally.
And they're paying.
No,
No.
not a
and-
penny.
and
I just wanted-
stay
I just
with
wanted
the
to-
document, because that's not
Stay
relevant.
up, yeah.
That's not relevant to the document.
But it is relevant.
No, it's not. Then you
Because,
should be at the other meetings, because that's not relevant to this document. So
Because-
please let him finish and don't interrupt.
What I was gonna say, which isn't, strictly speaking, is not fodder for this meeting. This meeting about is what's in here. What I can tell you unequivocally, and if any lawyer tells you otherwise, they're wrong. Okay, camera behind me, so you get a copy.
I don't take it with my
A person, whether we're talking about an advisory committee of a municipality, whether we're talking about the municipality itself, whether you're talking about a private a person who says, I'm going to sue you, does not have the right, even if they're a citizen of that municipality, or standing or otherwise, to have any say in who the target of that lawsuit decides to use to represent
Oh,
them.
I'm not.
But
I'm not.
that
Not
said,
at all.
since it's continuing to come up, we work for free. They are our client. We stand behind what we draft. And if not this group, but if the town board, acting in executive session, which would typically be the case, and is particularly important, when somebody has said, I'm going to sue you, if the town board decides in its wisdom that it wants us to take any role in the litigation after they have considered all the facts and circumstances, then if any of that role if part of that includes us in whatever role, absolutely, I'll tell you what I'll tell them at the time, we are there and we will be there and we will be there for free.
Okay.
Is there any other?
Yeah.
Can I be more unequivocal
Well,
than that?
this goes along with the document that's being presented tonight, that on the 18th of January, I believe, you were supposed to have met with Houston Benson Insurance.
We did.
Houston Benson Insurance is aware of the litigation that's going on in the communities. Is the town board then aware that if Houston Benson Insurance or any other insurance company will not indemnify against legitimate legislative activities that are taking place in the state of New York, drilling is taking place here?
How is this relevant?
Because this.
No, let her go. Let her finish.
Because this is relevant, because the town board needs to understand that when you take
Let me
this,
just say,
this
sometime,
community-
I don't want to, but let me just say, that's a terrific point. May I?
I would like to finish,
but-
actually.
Well, I'm going to interrupt. This ain't the town board.
I know
So it
this isn't
should
the town
go-
board,
that should
but
be
this
directed
is the
to the town
committee
board.
that's advising the town board.
Okay,
And
first
therefore-
off, on that issue, 3 of the town board members met with Dallas County. Harold Cows, Barbara Snyder, and myself.
Yes.
That was explained to us exactly about that liability issue and whether or not they will cover us only if we pass a law that is not in compliance with state law.
Exactly.
According,
Article 23.
wait. According to state law, local rule, home rule, has precedence over 100 years in this state. So the town board, wait, I'm answering
And I'm
your
going to
question.
differ.
The town board is very aware of what Mr. Genny said. And that's not for the insurance company to decide, but for the courts to decide down the line whether or not these laws are in compliance with state law.
Okay.
That's not to be decided right now here. And the board is very aware of that.
And in that essence, that as a town board members, you are taking my tax dollars and putting them in jeopardy to defend your decision to enact this law that does not coincide, and it's creating supersedure over the Article 23.
Duly
Okay.
noted.
If you do this,
And we're done.
Duly
and
noted.
I have one other thing about this, because if you
Unless
do
it's
that,
relevant
the
to the
town
document, because it's not.
Yes.
Let's talk about something.
Specific.
Yes, because
Okay.
specifically, if you enact this and I can't develop my land, I would be filing a lawsuit. And I won't be suing the town board, I will be suing,
Are there any
I
other
will be
comments
suing
from
the
the floor?
individual
Because
town
this is
board
not
members,
okay. Yes,
because
ma'am. We're
indemnity will
sorry.
not
We're
take
done.
place for
We're done. This
insurance.
is not the case, the situation for you to do this. Yes, ma'am.
Patricia Barlow, I'm a resident of the town. I'm just wondering if another town
He can do whatever he wants, but I'm gonna
allows
sue him.
gas drilling, and they want to pipe the gas through our town, across
Absolutely.
my land, like to meet the gas line in Colliersville. Is there anything in this to prevent that from happening?
Yes.
If,
I wanna hear what you have to say.
if it is there are certain pipelines that the town has authority over, and there are certain pipelines that the town has no authority over. If we are talking about pipelines, if what they want to do with those pipelines are pipelines that are not regulated, the pipelines you're worried about, if they are of a nature, size or otherwise, that they are not regulated by the state or the feds, then under this law, the people can't do that over your property. If they are of a nature, size or otherwise, that the town has no authority over that, essentially because they are treated as if they were public utilities, then you can't, then the town can't do anything about that. But with respect to gathering lines and things like that,